Justice Kureshi, Learned Advocate General, Sriram, Justice Indira Banerjee, High Court judges, ladies and gentlemen. How did the present system come into place? Why did it come into place? How is it being worked? Are all questions that we ask ourselves today. I want to take you through a brief history of how we have ultimately come to the second judge's case, what it really laid down, how it is being worked today, and whether any better system is possible. Mind you, I have really struggled with myself to try and think of some answer, and I have come up with one, which I'll share with you today. But to begin at the beginning, the founding fathers had an array of judicial systems and judicial appointment systems before them. And they really focused on two. One, the US system in which judges don't count at all. And the other, the English system, where you had a Lord Chancellor wearing 3 hats. So that when he wore the judicial hat, he sat in the House of Lords as its presiding officer. When he sat otherwise, he sat as a member of the executive, being a minister. And thirdly, equally, he would sit as a person who was in both capacities, as both judge as well as legislator. Now, in England, it is the Lord Chancellor who ultimately, after making consultations with various persons, gave a particular judge his name to the executive, and then the executive in due course appointed him. The American system, though it involved the president alone initiating appointment, and the upper house, the Senate, ultimately by a simple majority saying yes or no to the person, is not a system that commends itself for many reasons. However, it's interesting to note it has somehow thrown up the greatest judges. And this is remarkable. Sometimes it happens by happenstance. Now, the great John Marshall, who was their 3rd Chief Justice, was a man who would never have become Chief Justice but for certain remarkable things happening. One, he was Secretary of State to President Adams, who was the 2nd President of the United States. And they were looking for a Chief Justice when Justice Ellsworth resigned. And it was in Adams's last days. So Adams kept asking Marshall. Marshall suggested John Jay, who happened to be their first Chief Justice. First Chief Justice declined. Then they went to one of the senior-most judges who were sitting, Justice Patterson. And then President Adams said, no, but Patterson wouldn't do because Justice Cushing is senior to him. But then Cushing wouldn't do because he had already said no, and things of this nature. And then finally he just turned to him and said, why not you? And this is how Marshall actually got appointed. He was perhaps the greatest Chief Justice in any jurisdiction. Because in his 34 years as Chief Justice, he actually made the United States of America. You must remember that the US is really a conglomerate of 13 states when it started, each giving up only portions of their sovereignty to a weak central government. It is Marshall who made that central government strong and who set the blueprint for the United States as it is today. Another great judge they threw up was Justice Holmes, who all of you have heard of. Now, Justice Holmes was appointed by President Theodore Roosevelt, and within a year disappointed the president who appointed him, so that he said that I could carve a spine easier from a banana than from this man who I've just appointed. And he turned out to be one of their greatest again, so he therefore was a maverick. And he again had a long tenure of 30 years. He was known for his great judgments on freedom of speech and for judicial restraint in the economic area. Then we had William Howard Taft, who again could operate within that system and become both president and chief justice. This is again something remarkable. First he became president, though he always wanted to become chief justice. And he appointed Edward White as chief justice, lamenting how much I want that post. I don't know why I am doing this. And then, of course, he left as president. And he was fortunate that President Harding, 7 years later, appointed him chief justice. And because he was president, he could lobby for a new Supreme Court building, which happens to be the building in which all of them sit today since 1935. Then, of course, you had the great Roosevelt appointees. You had Justices Douglas, Black, and these people, again, were outstanding, except that for the first 5 years of Roosevelt's presidency, he found that the old guard, so to speak, those who were 70 and above, resisted every New Deal legislation that he was trying to come out with. And 5-4 by a majority, they stuck down legislation. So that he thought of a unique court packing plan. And he said, for every justice over 70, we will appoint a new justice so that we make it now a court of 15, because there were 6 above 70 at that time. Fortunately, that didn't transpire because in 1937, one of the justices switched his vote and it became 5-4 upholding such legislation. Then we also had the great Warren era, where Earl Warren, who was a governor of California and not a judge at all, proved to be one of their greatest chief justices, with Justice Brennan in tow. And they were appointed again by a Republican President, Eisenhower, who again ruled the fact that he appointed a man like Warren as Chief Justice, because within a year of his Chief Justiceship came the seminal decision in Brown versus Board of Education, where racial segregation was sought to be done away with. On a sideline, they also appointed one of their weakest judges, a judge named Charlie Whittaker. And what I'm about to tell you is true. Whittaker walked out of a conference, because they used to hold conferences and the Chief Justice would decide who would write the majority opinion. So in this one particular case, United States versus Myers, he told Whittaker, Charlie, why don't you write the majority? And Whittaker walked out. Douglas was leading the minority. So Whittaker goes and tells Douglas, Bill, it'll be so difficult for me. I don't know what this case is really about. So Douglas said, oh, why are you bothered? I'll send you a draft. So you actually have a judgment of the US Supreme Court where the same justice has written the majority and the minority. You have Douglas's draft with Whittaker signing and Douglas as the minority. Anyway, you have all these funny things happening in that system. Judges are no part of that system. And somehow or the other, we chose the British system. Now, the British system, as I told you, consisted of a Lord Chancellor who wore 3 hats, so the judiciary was represented. Here, under our Article 124(2), when the President appoints judges, is the President alone appointing judges. There's no Lord Chancellor here. Which is why you have 2 other very important provisions. One is that that President can consult as many judges as he deems necessary for the purpose of appointment, and those judges can be Supreme Court or High Court, but with a proviso that in every case he has to consult the Chief Justice of India. How did this system work? Incidentally, our first Supreme Court was bodily lifted from the Federal Court, so that the 6 justices of the Federal Court became our first 6 Supreme Court judges. And of course, we had Justices Chandrasekhar Iyer and Justice Vivian Bose appointed to complete the number 8, which was the original number. And in the beginning, Justice Kanya was supposed to have lived for about 10 years and would have been chief for 10 years, but he died within a year. So the next senior-most chief judge was appointed Chief Justice. There was no convention then yet, but Justice Patanjali Sastry followed. After Patanjali Sastry, there was a problem, because the Prime Minister did not want Justice Mahajan, who was next in line. And he tried to sound out Chief Justice Chagla from Bombay to try and come. He tried to sound out Bijan Kumar Mukherjee, but fortunately none of this worked. And finally, because there were threats of resignation generally, Mahajan did become Chief Justice, and therefore one important convention was laid down that the senior most judge, therefore, will invariably become Chief Justice. It had not happened in the federal court. Incidentally, Justice Vardacharya was the senior most judge after Chief Justice Maurice Guyer went. And Justice Vardacharya was superseded by bringing an English judge, Sir Patrick Spence. Chief Justice Guyer wrote a letter to Lord Linlithgow, who was the Viceroy, lamenting the fact that they didn't even bother to consult him. And Lord Linlithgow very graciously wrote back and said, yes, you are perhaps right. We should have consulted you and should have stuck to the seniority principle. But anyway, fortunately, after the Mahajan episode, seniority as the senior most judge would then become Chief Justice was something that was set. Also in the first 18 years, the system worked well because two other conventions also developed. One was that the Chief Justice would give a name and not the other way around. So the Chief Justice would give a name for a vacancy in the Supreme Court and the executive appointed by and large, unless there was something radically wrong, in which case either the Chief Justice accepted it or if the Chief Justice insisted, then the executive deferred to the Chief Justice. In fact, in the case of Justice Raghubar Dayal, it actually deferred to Chief Justice Sinha because it voiced strong objection, but Chief Justice Sinha overruled them. And that went on for about 18 years. The problem really arose for the first time when Hidayatullah became Chief Justice in 1968. And he wanted two persons at the end of his tenure, just Chief Justice Kotwal from Bombay and a judge called Justice Menon, both of whom were not appointed. So Chief Justice Hidayatullah left without two persons being appointed for the first time by the executive. Justice Shah, who followed, had a short tenure of 30 days. And in those 30 days, wanted Justice Bhagwati to come up at that time. And the executive said no. So already we find that there is erosion creeping in. And then finally, in Chief Justice Sikri's time, we actually had a reversal of roles because the government now started giving names. The law minister actually gave Chief Justice Sikri two names, that of Justice Chandrachud and Palekar. And the Prime Minister herself gave two names, that of Justice Dwivedi and Justice Beg. But when they gave the names of Justices Krishna Iyer and Nagendra Singh, who later became our World Court President, Justice Sikri put his foot down and they listened to Justice Sikri, at least insofar as the putting of his foot down was concerned. But the greatest threat really came after Kesavananda Bharati. All of you know that by a 7-6 majority, the basic structure doctrine was laid down and the absolute eve of Chief Justice Sikri going. And as soon as the judgment was pronounced and the Chief Justice demitted office, 3 judges were superseded. Now, this happened for the second time because the first supersession in 1965 was because Justice Imam was actually unfit. So that was a supersession which had to happen. And the next senior most judge, Justice Gajendra Gatkar, became. But this time, it was 3 senior judges who sided with a particular point of view who were superseded. And Chief Justice, the man who became Chief Justice was Justice Ray, who was constantly in the minority in a number of judgments and with the government. And as Mr. Daftari put it at that time, the schoolboy who wrote the best essay got the first prize. So that Chief Justice Ray then became. And this was the first blow struck at the independence of the judiciary, and it was a big blow. The second blow occurred shortly after, when Mrs. Gandhi lost her election case in Allahabad and an emergency was declared. Now, close on the heels of the emergency, you had a 39th Amendment Act, which in essence put the Prime Minister and the Speaker above the law. Because it said that you will now decide her election petition not in accordance with law, but in accordance with this amendment. This amendment lays down no law except to say that you will allow the appeal and nothing else. So that what followed was, for minority judges in Kesavananda, applying basic structure for the first time to strike down such an amendment. It's a remarkable thing that happened. And immediately when this judgment was delivered, which was between 7th and 9th November of that year, in 75, immediately after, Chief Justice Ray called a 13-judge bench within 2 days to review the basic structure doctrine. Now, this is where Govind Swaminathan stepped in. And we have to thank him because judges started asking inconvenient questions to the learned Attorney General at that point of time. Justice Khanna, for example, asked him, does the doctrine come in the way of any socio-economic legislation? The answer given was that no, in any case, there's nothing like essential and inessential. So obviously there was no real answer given. And the judges got testier and testier until suddenly Chief Justice Ray was put into a corner and they started asking, why was this bench constituted? So he said, well, the Advocate General of Tamil Nadu wanted it. So Granville Austin tells us, Govind Swaminathan jumped up and immediately said, I didn't want it at all. So at that point, again they said no, but then the Advocate General of Gujarat wanted it. So the Advocate General of Gujarat also got up and said, no, I didn't want it. At which point then, it became impossible. And thanks to Mr. Palkhiwala's forensic eloquence, which reached heights which apparently have never been reached, within 2 days that bench was dissolved. And Kesavananda Bharati remained, so that one massive threat to judicial independence went there and then. But then there were other dark clouds looming on the horizon. One very dark cloud was the habeas corpus case. And the habeas corpus case again was decided by a majority of 4-1, Justice Khanna dissenting. And Justice Khanna's dissent was fortunately appreciated and made the law by me sitting with 8 other judges. And that was 43 years later when we said that Justice Khanna was right and the majority were wrong. That was one of the great things that I did in my judicial career. To have righted a wrong even though it was 43 years late. And of course, the other wrong could never be righted. He was superseded because of that judgment, with Mr. Palkhiwala writing a brilliant article in which I think the last line read as follows, that to the stature of such a man, the Chief Justiceship of India can add nothing. So this was the second very, very important blow to judicial independence. A third blow was 16 judges who were courageous, like Justice Kureshi, and who were transferred as a result. And that led to the judgment in Union versus Sankal Chand Sheth, because Justice Sheth was one of those who had struck down orders under MISA, that is the Preventive Detention Act at that point of time. And again, by a majority, the court ultimately held that everything was within the hands of government. The transferee judge need not be consulted before he is transferred. And consult means consult. Of course, due weight will be given, but the ultimate decision is that of the government. So that was the first blow that was really struck against judicial independence. And then after Sankal Chand Sheth judgment, our courageous Justice Khanna became chairman of the 80th Law Commission. And Justice Khanna then suggested something remarkable. He said that, look, for the first time, we should have a Chief Justice flanked by senior judges. This happened for the first time in 1979. And in his report, he said that you should be flanked by 3 senior judges when it came to Supreme Court appointments and 2 new senior judges when it came to High Court appointments. And of course, that was never followed, but that was something mooted way back in 1979. And then, of course, the stage got set for what is called the first judge's case, which is S.P. Gupta versus the Union of India, which was a 7-judge bench. And there again, important questions were asked about confirmation of persons who were additional judges and persons who got transferred. And the answers given were the same as that in Sankalchan Shet, that you don't need to consult the judge in question, that ultimately it is the government alone who decides. And above all, when it comes to High Court judges, and there are other consultees as well, such as the Chief Justice of the High Court and the Governor of the state, the Chief Justice of India has no primacy. So that therefore, the government could select whichever view it wanted or not select whichever view, so long as there was effective consultation. Now, this was the unsatisfactory state of the law. And in 1987 then, you had the D.A. Desai Law Commission and the 121st Commission report. Because in that report, for the first time, it was mooted that there be a Judicial Appointments Commission, 11 members, of which 8 were to be judicial. And the judicial members were the Chief Justice, 3 senior judges, a retired Chief Justice for the first time. This idea of a retired judge comes here. 3 Chief Justices of High Courts making up 8. And then you have the Attorney General, the Law Minister, and 1 academic. This, of course, didn't, again, bear fruit. And then finally, you had a 2-judge bench look into the matter again in Subhash Sharma in 1990. And that bench doubted the correctness of the first judge's case, which is how a 9-judge bench got constituted. And this is how we now come to our present system. Because the 9-judge bench now held for the first time that independence of the judiciary is part of the basic structure of the Constitution. Therefore, every article that is viewed will be viewed in this light, the light of this principle. And when you view it in the light of this principle, Article 124(2) and 217 take on a completely different meaning. So that now, when it is mandatory for you, the government, to consult the Chief Justice, consultation is no longer just consultation, it is concurrence. So that for the first time, the view of the Chief Justice became binding on the government. Second, and equally important, for the first time, the Chief Justice was not trusted alone. He had to be flanked by 2 senior judges at that point of time. And the same for the High Court Chief Justice and the Governor, who had to be consulted. And above all, primacy was to be given to the view of the Chief Justice of India, so flanked. So this actually turned the tables and turned the entire present system at that point of time on its head. So much so that judicial appointments now were in the hands entirely of the judges. Other important things were also laid down in that judgment, which unfortunately have not been followed. One is a timeline within which the other constitutional authorities have to respond. Now, 6 weeks was laid down by the majority judgment, in which the Chief Justice gives his view or his name to the government. Government has to respond, and 6 weeks are given. Suppose it's a High Court judge. Various authorities have to know what each authority has said, so a further period of 6 weeks is given. At the end of which, if there is a reiteration which is unanimous, that is, all 3 say, the Chief Justice and the 2 senior judges, say that you have to appoint, then the government has to appoint within 4 weeks. Now, all this is laid down, but has never, unfortunately, actually been followed. So the system is not a bad one. The system, unfortunately, has never really been followed. And nobody has ever said that, look, 6 weeks have passed. How are you still sitting on the file? In fact, that's not the question. The point is, you should write a letter saying 6 weeks have passed, you have nothing to say. Within 4 weeks, please appoint, but that's never been done. So this is the first flaw in an otherwise good system. And this is why we have seen this unseemly thing of the government sitting out judges who they don't like, so that a different collegium comes and then the name has to be given afresh. So the working of the system is what has led to a lot of problems. In 98, there was a special reference made and another 9-judge bench constituted. And that only tweaked this system by saying that merit is the first thing to be considered. Of course, you give some weight to seniority, you give some weight to region, but merit first. And you now broad-base the collegium into, instead of 3 in the Supreme Court, you have now 5. You have the Chief Justice and 4, and the High Court, it remains the Chief Justice and 2. But the whole unfortunate part is that, as I told you, this was not being worked as it should have been worked. And then, of course, you had various bills that were passed or sought to be passed from time to time. You had a bill in 1990 which had a particular system where only judges were involved. And at the High Court level, the governor also came in. You had, in 2003, a bill which lapsed, which sought to make the Venkatachalaya model the model of a judicial appointments commission, which was essentially that you have a Chief Justice of the Supreme Court, 2 senior judges, and then you have the law minister and 1 eminent person who is selected from a panel. That also lapsed. 2013, then you had one other bill where you had an equal representation in a judicial appointments commission to be laid down by an act of parliament. That also lapsed. Until finally we now come to the 99th Amendment. And that amendment, we are told, was passed unanimously with just 1 member of the Rajya Sabha dissenting, Mr. Ram Jethmalani. Otherwise, it was passed unanimously. And that amendment said that you will have the Chief Justice, 2 senior judges, and you'll then have the law minister and 2 eminent persons to be selected from a panel which consisted of the Prime Minister, Chief Justice, Leader of the Opposition. That, as you know, then got struck down by a 4-1 judgment in 2016. And today, this is where we stand. Now, the misfortune of this system is, 1, it has not operated according to its timelines. 2, it has not somehow thrown up the best. We still have persons like Justice Kureshi and many others who have somehow not reached us. Because, essentially, they have been found to be as meritorious as you can be. If you are too meritorious, apparently, you are out of the zone of consideration. And that merit consists of being fearless and really independent. So the moment you are really fearless and really independent, out you go. This is the unfortunate part of a system which is meant to protect us. So, what other system could be better? I agree with Justice Kureshi that this is like democracy, a system with huge flaws. We can perhaps better it, make it more transparent, etc. Certainly better than the executive appointing. But is there some other system which can be put in its place? Now, having thought a lot, I came to the conclusion, and I took this from a letter that Justice Khanna wrote in 1980 to the law minister, that why don't you have a panel of the Chief Justice and 3 retired judges? According to me, if you have a panel of a Chief Justice and say 4 retired judges and nobody else, it will subserve judicial independence, but then the problem is how do you appoint the 4 retired judges? Because that's another major problem. And if you appoint them for long enough, then transient Chief Justices won't be a problem. So if you give them a term of 5 years again, no problem. I have thought of a method in which they could perhaps be appointed. You could first have names given by practicing members of High Court bars and the Supreme Court bar. Now, practicing member would be a person who would, you can define it, would have at least 100 filings, 150 filings, 200 filings in that particular court. together with arguing cases of the same number. Now, if you have these people who were to select, say, one or two judges who they are told they must select because they must only look at constitutional values being protected and nothing else, you would then get about 22 names or 44 names from the High Courts. Likewise, you could get a panel of 20 names from the Supreme Court. And from these names, which would then number about either 40, 60 or whatever, you could then have the entire Supreme Court judges sitting, deciding as to who the best person would be, and then have a panel of 4. So that if the entire Supreme Court, today we have 34 judges, you keep the Chief Justice apart because he is going to be part of the panel. So you have among 33, each one voting for the person he thinks is best. And if you notch up the maximum number of marks from these, then the person who notches up the maximum number of marks, followed by the second, followed by the third, followed by the fourth, could perhaps be the pool of retired judges who then become a permanent commission for a period of 5 years. And once these persons have the power to appoint, then of course they will consult everybody, because the important thing also is to get as many inputs as possible. So the widest consultation possible, after which finally by a majority, if these persons say Mr. X is to be appointed, he has to be appointed within, say, a period of 2 weeks or whatever. I cannot think, I've been racking my brain, I cannot think of any better system. Of course, today in England, you have the Judicial Appointments Commission, consisting of 15 persons. But there you have a lot of lay persons. So you have an equal number of lay persons with judges, 2 members from the bar, and 1 person from a judicial tribunal who is not a judicial member. But I don't think lay persons is a good idea, because lay persons are liable to be influenced. I don't think they know. Retired judges are in the know, in the loop. They know exactly who to appoint, who not to appoint. And particularly if they are outstanding persons, then you probably will get an excellent crop of persons, and you will get what Justice Verma envisaged in the second judge's case, which is persons of outstanding merit, meaning thereby persons imbued with constitutional values. Of course, all this is utopian. But at some point of time, maybe this will happen. And if it happens, at that point of time, utopia will come to the earth. Thank you all very much.